I may be permitted to mention 2008 first appeal matter regarding the enhancement of compensation.
I have requested everybody to wait for this week. So come on Monday.
Monday.
Yes. My lord, extension of interim order. My lord, the interim orders
There were contempt application. Your lordship had passed the order in March 2000.
We'll sit one day. Don't worry.
So one order for 2-1, my lord, the rejection of the injunction application.
Whatever.
First week is the order for 2-1.
Keep order 41. Yesterday, the entire matter, order 41 was called. Nobody was here.
The fresh matter, a new matter, the actual cases.
No, under compelling circumstances, I have to mention item 17.
What is compelling circumstances?
17? Because section 5 has not been filed. No, I yes, 1 week time to enable me to file the application section.
What is there? File it.
Make it not.
There is no limitation for that. File it.
I said file. You are in absence of section 5. That's right.
Second appeal.
No, well, first appeal
Okay. Of which year?
of my lord has this of year 2000.
Now you are filing.
No, that is application was dismissed.
Okay. ওটা করে দাও, not this week করে দাও দেখি।
May I have your lordship's kind leave, my lord, to mention, my lord, for inclusion of a my lord appeal, and my lord, the stay, my lord, the contempt application is pending, which is returnable on 17th of January.
Appeal we are not hearing now. Please come in the next week. Let us see some matters.
My lord, it is
Application we
My
can
lord,
take.
new application. Yes,
Application you get.
I'm grateful.
May I have your lordship's kind leave to seek for leave to move an urgent appeal arising out of an order by which today at 12 p.m. a rally is supposed to be held near SSKM hospital. My lord, we had yes, my lord, we had mailed the Honorable the Chief Justice. In the event the bench number 1 does not sit today, we have this urgency.
That is sitting there.
No, my lord, the Honorable Chief Justice has granted us leave by a mail I have received to move before your lordship's bench so that the matter can be heard expeditiously if your lordship so permits.
Where is the
Yes, my
file?
lord, I am placing it for leave, your lordship's leave. I have the,
Give.
my lord, if it commences.
Give.
No.
Where is the file?
Yes, my lord, I am. Everything.
You are not equipped.
My lord, I have ready.
Yes.
I'll place it.
Yes.
This is a matter of second appeal for fresh matter which was filed in 20.
Order 41. Admission.
Second appeal.
Second appeal, we don't have a determination, madam. It's the admission, order 41, rule 11. You don't know, your senior has not instructed you. Second appeal has to be heard by a single bench. It is only the admission will come to us.
Only thing is the rally commences from 12. I will make everything ready.
Sir, you are not coming with the papers. You are saying many things. Unless you go file, can't be done. Just call the.
Met with lordship.
Appeal allowed. Order of the single bench is set aside.
Grateful. Madam for the appeal.
Appeal allowed. Order of the single bench is set aside.
Grateful.
Take 1 and 2 onions.
With a calculated answer site.
Sir,
Item 3. The suo motu writ petition is assigned to this bench by the Honorable Chief Justice.
বলছি বেড়ে গেছে wetlands 26টা থেকে 85টা হয়ে গেছে। Application send out.
No.
Science money included.
Have you seen that order?
Yes, but I'm having a look at it.
I'm also for the first time is looking at it. And the chart list of 85 Ramsar sites, have you come across paragraph page 13?
Yes.
If
How
you
does it
come to
towards
page
the-
16, if you come to page 16,
Yes.
the last one, 74,
West Bengal.
is Calcutta and the Sundarban. And they have identified 12,500 for East Calcutta and 4,23,000 for Sundarban.
But we have a statute
Yes,
which has
inland waterways or something.
which has a East Kolkata wetlands. There's a East Kolkata wetland some act which has a schedule.
To show us,
Yes, but we have to come back prepared, my lord. I'm
we
not
also don't, because there is nothing which is on record. We wanted
Yes, yes.
I think the affidavits or the facts disclosure, everything to be done.
Nothing we, but in any case, there are several writ petitions have been filed so far
No, this judgment after this,
where there is specific orders
it-
of injunctions also.
I think it says the Registrar General of this court is
Ah.
directed
Hmm.
to send the complete list to the all high courts, including 5 high courts, which are mentioned above. 5 high courts have been mentioned and we are included.
Right.
If you come to page 12, says now the latest figure shows that these Ramsar sites have increased from 26 to 85, including 59 additional sites, falling under 5 other additional high courts, Patna, Bombay, Karnataka, Guwahati, and Uttarakhand. The list of the update has been given to this court, which is reproduced as under. Sorry, I think we will get it from here. Page 11, there is an order of 3rd of April 2017 is reproduced in the order. Have you got that page 11?
Yes.
It says, we have put it to the learned counsel for the petitioner that insofar as Ramsar convention sites are concerned, since they are the matters of international heritage, it might be more appropriate if the concerned high courts monitor the management of these sites. At least till there is some visible improvement. Learned counsel for the petitioner says that he has no objection to this. Under these circumstances, we direct the registry of this court to make photocopies of the affidavits filed by the Union of India and the member secretary Central Wetland Regulatory Authority and send it to the following high courts. High courts of Hyderabad for Telangana and Andhra, Guwahati High Court, Gujarat High Court, Himachal High Court, Jammu and Kashmir, Kerala, Madhya Pradesh, Manipur, Odisha, Punjab, Haryana, Rajasthan, Madras, Tripura, Allahabad, and High Court at Calcutta. The affidavits be sent to the Registrar General of all the concerned high courts within 2 weeks from date. Copy of all these orders. These affidavits are required.
But affidavit, your lordship will find page 14.
There is no page 14.
But page 14, this is the affidavit filed
Oh,
by.
this is the.
Yes. And your lordship will find the state of West Bengal last but one page. The area, the steps taken, the activities under blood, and the what steps was taken. 26. দাদা এটা এই জাস্ট এইটার পরে অর্ডারটার পরে
So take a step. We are just simply adjourning this matter and keeping this matter on Monday because this is the first time it has come. Take instructions. Please also disclose the several writ petitions which are filed, PIL, regarding this wetlands, Ramsar sites. Disclose that, come with that, we will pass a direction for filing of the affidavits and all, everything. And then preventive orders are already there, as you said. He said that there is already there.
There is an act, so far as West Bengal is concerned, your
Correct.
lordship knows better than me. The East Kolkata Wetland Act.
Correct,
There is a regulatory authority also.
correct,
By the state.
correct,
The Pollution Control Board is the authority who is monitoring the entire issues.
correct.
So the affidavit has to be filed by the state of West Bengal.
Absolutely.
What steps they have taken.
Well, that is what we wanted.
But
So
I think
let them
subject to
come because
correction.
he said that he has nothing. So he will take instruction.
As your lordship, please.
So let him come on Monday.
Subject
And I
to
do not
correction,
know
I think
what
we are-
happened after 2017. The order which was quoted, I don't know what has happened thereafter.
But I believe, my lord, some records must come from the NGT also.
I do not know. Nobody, because the order of 3/4/2017 that shows we request the Honorable the Chief Justice of the concerned High Court to treat the affidavit as a suo motu public interest litigation. And if necessary, appoint an amicus to assist the court so as to ensure that the Ramsar Convention sites within their jurisdiction are properly maintained.
To my recollection, my lord,
But
I think
there are
another matter pursuant to that order was registered where Mr. Joydeep Kaur was appearing. I'll
Can
talk
you
to
give
him.
me that? Because we overlapping. This is really an overlapping. So everything has to be tagged together.
And the other thing is, my lord, today,
But following-
in 2021, I think the rules have changed whereby the wetland authority, the entire jurisdiction has now gone to the central government.
No, my lord, the Ramsara Convention held in Iran in 1971. Following that convention, the West Bengal, they have implemented an act. It's called East Kolkata Wetland Act 2006.
Correct.
And there, my lord, your lordship will find there is a regulatory body and ultimately the Pollution Control Board is, my lord, helm of the affair.
Okay.
So they need, your lordship needs to
Central Act.
Complete them also a party because we
Yes.
wanted them to be a party here. So come with the data.
And in the
On Monday.
affidavit, your lordship will find that last but one page, 26, item number 26.
Correct. We have seen East
Yes.
Kolkata.
Yes, East
But-
Kolkata.
But by this order, the Sundarban area is also included.
Yes, my lord, that is not there. Sundarban area is also there.
Yes.
That is the, my lord, the natural reservoir. To protect this natural reservoir, my lord, this order was passed.
So come on Monday. We are fixing this matter, Mr.
I
Advocate
think,
General.
my lord,
Take
Monday would
instruction.
be too short a time. Make it my lord, Monday week.
Why?
Only one working day in between.
Monday.
As your lordship.
And my lord,
This matter
please
has
pass
come
a direction, please consider passing a direction on the NGT to give us some, my lord, statistics as to whether Ramsar matters are pending over there or not.
Now, first the Pollution Control Board, they may
It's
apprise.
a separation, absolutely independent body. So I don't think so that it is desirable
try
at this
to-
stage. At this stage, it is
But
desirable.
there are number of matters there pending, I know.
So, no, so that is why unless you disclose by way of an affidavit that there are certain matters which are there, then we can't.
যে কটা পারবো করুন। To
Whatever
the
you
extent
get.
possible, my lord, we'll be disclosed.
This matter has come up. Somebody has mentioned. Priya Nandi.
Then respond.
This has already been finally disposed of.
Yes, my lord.
What correction? Though the matter was mentioned for correction of a ministerial.
One, two, three.
Plant is lengthy argument. Lengthy argument.
My lord had,
The argument was concluded.
yes, and lordship had kept it.
Just to remind your lordship, my lord, this is the Krishi Vigyan Kendra, the project of this central government.
Central government, ICAR.
ICAR, and on a ratio, the cost ratio, 60%, 40% will be borne by the center and the state, etc. Now, my lord, an agreement was entered into in respect of different Krishi Vigyan Kendras between the concerned.
Just lost the track
Oh, then I
during this vacation.
Then,
Just recapitulate so that I will remember everything.
yes,
and
I do it just.
very well.
Okay.
Lordship, do we give a note or something if that's?
No, I
Right.
take a short time, my lord, just to remind your lordship of the situation.
Yes, it was. Good. Defective also.
Possibly your lordship took some note also.
Okay.
Yes, yes.
Delay has been condoned.
Yes.
Yes, yes. Yes,
Yes.
yes.
I had filed an application under Order 41 Rule 27 also.
Oh, yes.
For additional documents, my lord, we had
So,
taken
because on 24/12.
exception to that.
And let the matter be listed on 8 January for further hearing.
Yes, that, my lord,
That
your
is-
lordship had kept it. Yes. No, your lordship had kept it just before the vacations. I was not here. My London Junior was here.
Yeah, can you
Yes,
repeat?
lordship.
Yes.
My lord, there were 18 lead petitions. My lord, who joined different Krishi Vigyan Kendras in different posts between 2001 and 2012. My lord, these are the different KVK, Krishi Vigyan Kendras of Ramshai, Jalpaiguri, and Ashoknagar in 24 parganas. My lord, these were taken over by the West Bengal University of Animal and Fishery Sciences in 1999. All these Krishi Vigyan Kendras were taken over by this particular university, West Bengal University of Animal and Fishery Sciences, in 1999, 2001, and 2005, respectively. These three Krishi Vigyan Kendras. Now, a memorandum of undertaking was entered into between ICAR and this university that the Krishi Vigyan Kendra staff will be taken over by the university and they will be considered as university staff with the same
Under the
benefit,
same service condition.
on the same service condition. Accordingly, the University Act was amended also by including these posts in the second schedule of the Act.
Okay.
Now, this was up till now, there is no dispute.
No,
Now, university, huh?
No, I don't think so. That's right.
No,
No, I don't think
if
that's
you
right.
please kindly take page 212. The first statute of the university, what the university staff are entitled.
105.
105.
I got it.
Kindly
Including
kindly
pension,
come to
gratuity,
clause 2.
insurance, provident fund for the employees shall be determined in the regulation of the university.
Yes. And the teaching and scientific staff of the university shall be governed by the University Grants Commission scales of pay allowance as implemented by
Where?
in respect to other allowances, skills of etc. Everything is there.
No, from where you reading? 105,
105 2. 105 2.
2. Okay.
The teaching and the scientific staff of the university shall be governed by the University Grants Commission scales of pay and allowances as implemented by the state government from time to time. In respect of other allowances, including travel allowance and other benefits for the university officers and staff, the rules and orders of the state government shall be followed mutatis mutandis. However, the council may effect modifications taking into consideration peculiar circumstances. Now the service conditions, are Millard all like this. Now Millard, if your lordships kindly take Millard page 228. This is the MOU I am referring to, the memorandum of understanding between the university and the KVK, the Krishi Vigyan Kendras.
Okay.
At
No, I see it.
228, this is Millard entered into on
July 2025.
yes, 1st July 2005. But Millard kindly take page 230.
The grantee.
The grantee, that is the university.
That is the grantee is the
Grantee is the university. Grantee is the university. Millard, if you are asked to kindly take 220, the first paragraph, you are still find the university, West Bengal, name of the grantee.
Name of the grantee is the West Bengal, it is a West Bengal University of Animal and Fishery Sciences. It's called the grantee.
Yes, grantee is
West Bengal University of Animal and Fishery Sciences.
yes.
Page 228.
Now 230,
Yeah.
clause 7. The grantee, the second party, in addition, agrees to.
Yeah.
Then kindly come to
Three.
7. 7.
3 or 7?
Right. Roman 7.
No, 3. My
3.
marking is 3 as well.
The scale of pay of the KVK staff should not be more than the pay scale. So I am not concerned with the pay. We are concerned with the GPF benefit here.
Okay.
Now kindly come to 7. Treat KVK staff at par for the purpose of privileges, amenities and facilities permissible to other staff of the grantee.
Okay.
Then Millard 231. If you also kindly mark this.
They will be born on the establishment. 8-2.
Yes. 8-2. Born on the establishment. Then 233.
Just 1 minute. All staff of KVA shall be born on the establishment of the grantee only. Okay. Then
233.
33.
At the top, Roman 5. The council will not be liable to bear any expenditure on pension contribution and a leave salary contribution or any other retirement benefits incurred or committed by the grantee in lieu of CPF, GPF, etc. Therefore, ICR says it's entirely your life.
Okay.
Now, Millard, 136
Then 234 also, there is a noting by me. Roman 35, 25.
Yes. That is something I had shown, Milord.
Okay.
Milord, if your lordships now take why we have come before the court. Page 136. These are the rights created in our favor. These were being denied. We approach the court.
137 type.
Milord, 136. 137 is a better copy. Milord, type it.
Yes.
130. In superseding all the previous orders relating to provident fund deduction from the KVK employees under the aegis of the university and following the decisions taken in the meeting held on 25th June 3, 2013, it is to order that the CPF for the past and present KVK employees to be calculated as now it says CPF, not GPF, at the rate of 10% of basic pay, paid payments such and such, 1 year after the joining the service in KVK, along with accumulated interest as per the existing PF rules. The KVK employees are directed to deposit their own CPF contribution to the finance section to the respective by demand draft payable at Kolkata in favor of WB University Animal Fishery Sciences. Therefore, they try to bring us under CPF. They try to bring us under CPF. Whereas the university employees, they are entitled to GPF.
Okay.
Now, that you will find at page 272. 272 is part of the affidavit used by the university.
By the
University. University's affidavit at page 272, the continuation of that. Roman 5 paragraph. Kindly come to the middle.
it was not placed. So there is no tag.
Below 5 in the middle. The provident fund for the university employees. Have you kindly got it?
Is GPF.
Is GPF. And we are traveling for this. Give us GPF. Now, why was this necessary to be placed before the lordship? In my second thought, I thought that I should place it. Previously, I didn't show it. If your lordship kindly take page 386. This is the DCRB rules of the state government.
DCRB.
Yes, DCRB rules. DCRB rules requested relating to the revision of the West Bengal State Aided University's death cum retirement benefit. 1986, etc. Then it says several
Kalyani University.
Number 11. West Bengal University of Animal and Fisheries Science.
Yes.
That is number 11. Kindly turn over. Page 387. Number 8. Concerned university will make necessary amendments in their statutes, ordinance, rules, etc., where necessary, for incorporation of the provisions of the government order therein. Therefore, Lord, the government order ordains that the university should make necessary amendment in their rules and statutes so that we can also get the benefit of GPF. Now, kindly come to 9. Bidhan Chandra Krishi Vishwavidyalaya, another university, and West Bengal University of Animal and Fishery Sciences may consider the implementation of the provisions of the scheme as annexed after obtaining approval of the Agriculture Department and the Animal Resource Development Department as the case. Therefore, to them, it does not apply automatically. Animal and Fishery Sciences, that does not apply automatically. But from page 272, it appears, my lord, that must be arrangements had already been approval already taken. They are brought under GPF. The university employees of Animal and Fishery Sciences have been brought under GPF. That is at page 272. Now, 386 and 272, I relate.
Yes, that's an affidavit.
Yes. That is the university.
Correct. They are the respondent number 2 to 4. Who are those respondents 2 to 4?
Respondents 4.
No, 1,
But
2,
this
and
is the
3.
affidavit of 2 to 4.
Yes.
Oh, he's a registrar of the West Bengal University.
Yes, yes.
The university. He's being affirmed by this man.
Correct.
By the registrar. Now, my lord, kindly come to page 376. What was held by the learned single judge?
79.
376. Judgment. That page 376. I will not, my lord, place the entire judgment. Finally,
Which
take
page?
page 379.
No, internal page.
Internal page 4.
Yes.
Page 379.
Yes.
Second paragraph. Importantly, the affidavit points out that the Department of Agricultural Research and Development, Government of West Bengal, introduced a contributory provident fund for KVK staff. The document I had shown to you, KVK staff, with the ICR covering the employer's share, while the employee share is deducted from their monthly salaries. The university continues to manage the contributory provident fund account. Why is this? The learner just merely records the fact that the university continues to manage the contributory provident fund, CPF. Additionally, the university states that the death cum retirement dues are applicable to university employees, but gratuity and pension are not applicable to KVK staff. That is what the university says. But How can it be? This is staring on the face of the memorandum of undertaking, on the basis of which the KVK staff were taken over by the university with the assurance that they will be treated as university staff for all purposes, for all benefits. Now then it is evident that the KVKs on the university operate based on the memorandum of understanding between ICR and the university, with no role attributed to the state government. Furthermore, the memorandum university is an autonomous body. Furthermore, the memorandum of understanding specifies that ICR shall not assume any financial responsibility for pension, leave, salary, etc. ICR need not. Then we are next. Clearly, there is no indication in any document that the university has ever regarded keeping employees as regular employees equivalent to its own.
But that is contrary because they have taken it.
Now, to prove that this is contrary, I have taken out the application under Order 41 Rule 27 because I did not have sufficient document before the learned signature. I don't say the learned signature is wrong on all counts. I don't say that. But the move was there, but other things were not there before the court. That is why, if your lordship now kindly take up this Order 41 application. Can number 3. Can 3.
Yes, you are referring page 15.
I am referring, my lord, to page 14. 14. That's it. 14. I start with 14. 14. This is a letter dated 17th January 2004 coming from the ICAR addressed to the university. Subject is Provident Fund contribution of KVK staff, Jalpaiguri regarding. This has reference to your letter number such and such on the subject cited above. In this regard, I am directed to inform that since the staff of the KVK Jalpaiguri are born under the West Bengal University of Animal and Fishery Sciences, the pay and allowances, including Provident Fund, may be regulated as per the norms of the university. This is what ICAR says. Now the next page. Another letter from the ICAR to the university. In view of the strengthening of the activities of KVKs, the QRT has suggested.
That is what is a
quinquennial
review committee.
Yes, review committee. Yes, in the subject it is mentioned. Has suggested measures to make certain provisions in the statutes of state-aided universities of West Bengal and Central University of Shantiniketan, so that no discrimination is done with the KVK staff in respect of the facilities like Provident Fund, pension, career advancement scheme, etc. No discrimination is done. A detailed report of the present status of the KVK staff as per the statute of the university may please be made available for its onward communication to the council. Moreover, the above mentioned issues need to be resolved at the earliest, for which I am to request you to kindly intimate a convenient date for convening a meeting at the earliest to settle the matters on the line of recommendation of the QRT. This is 2007 letter. Now we are in 2025. Now the next document, page 16. This is not the DCRB, which I showed you.
Which you showed from there.
These are the 3 documents which I beg to rely on as additional evidence, because these will be necessary for your lordship
to pronounce judgment.
Yes. Additional evidence judgment. There are no great points of law are involved. It's purely based on these documents. My entire claim is based on this.
Yes.
Lord, if your lordships need any further clarification after hearing my learned friends, I'll assist.
Well, I appear for the respondent number 1, 2, and 3, the university and its authorities. Now, to start with, my lord, the relationship here that exists in this particular matter is that of a contract between ICAR and the university, and thereafter appointment on the basis of that contract with the employees. Now, I had on the previous occasion relied upon the memorandum of understanding. That is basically the principal document. And it says, the last clause that my lord was at that time pointing out, 25, that page 234, my lord.
Yes.
For contravention or for non-complying with any of the conditions of the MOU by the grantee, council can terminate the project without giving any notice for the same and without any liability whatsoever.
Between you and the council.
Yes.
The
And
council may terminate.
yes, so the principal document on which the entire project stands, the KVK projects are a project of the ICAR across India. We are handling projects here in West Bengal. Now, the project entirely stands on this one document, the MOU. The statutory obligation of the state government has nothing to do with this.
You are not a state government.
Yes.
You are a
So,
university.
yes. So,
University.
so my principal grantor is the ICAR. They are the principal. I am an agent.
Consider.
Yes, my lord.
Your liability, your right emanates from the memorandum of understanding. You, with the conscious mind, knowing everything that what is there, entered into this contract. It is a concluded contract.
Yes.
The conclude. You have consciously taken a responsibility of this entire project.
Yes. I am not.
Now,
Yes.
this is what it says. When you come to page 230, what he's showing is Roman 3 or a Roman 7. First thing, Roman 3 say the pay scale of the KVK staff should not be more than the pay scale approved by the council for the scheme, and the qualification of the staff should be commensurate with this. So
Right.
that is what is one embargo which should be there. You cannot.
Yes.
7 is treat KVK staff at par for the purpose of privileges, amenities, facilities permissible to other staff of the grantee. Grantee means you. So all the privileges, amenities and facilities which you are extending to your regular staff, you are bound to extend those amenities, facilities.
Well, subject to this contract. Well, subject to this MOU.
Let me go then on a very basic
Yes, my lord.
nuances of the Contract Act. Then I have to take an academic class for this.
Oh, my lord.
When you raise
I'm
this,
always,
then I have
will always
to
be a
get
privilege.
the very grassroots level of the Contract Act. What does it mean? This is a part of the contract.
Yes.
What are the terms of the contract?
Yes.
If the terms specify that what you will do and what you will not do, you can't say anything beyond that. This is very categorical that you will treat, though they are not your regular employees. Yet, by virtue of this clause, you have to treat them at par with your employees. So far as the privileges, amenities, and the facilities are concerned. Now, there is only one scope of argument is that what would it mean by these three magical words? Amenities, facilities, and the privileges. Whether it encompasses within itself the GPF, CPF, pension, the scale of pay, or what.
Right.
These are the things one can say that whether it comes within the ambit or does not come within the ambit. But you can't say that no.
No, I'm not saying. That is what I am saying.
Subject to contract.
And there, my lord, the question of what is the pay scale that is being implemented? The pay scale that is being implemented
That is what
is
is
for the central pay, which is 7th pay commission, whereas the state goes with the 6th pay commission.
Roman 3 of this says that the pay scale of the KVA staff should not be more than the pay scale approved by the council for the scheme and qualification.
Correct.
So,
And
the council did not say that what should be the pay scale. Council says that what the KVK were getting, you have to take
yes,
them as
and
it is.
that was in terms of the 7th pay commission. We have put it on affidavit also before the trial court.
And
my lord,
and then the 8-2 that come to 8-2 at page 231.
yes, my lord.
All staff of KVK shall be borne on the establishment of a grantee. So liability is foisted upon you. You can't shy away from your responsibility.
Yes, yes, but liability is also on the ICAR.
With deepest of respect, no. You have entered into a contract and you know
Well, my lord,
what is the nonsense of the
kindly see the nature of the appointments. Well, I had shown.
immaterial, sir. When this KVK, in terms of this agreement, includes this, then you can't. Can't. And then you are referring to this last clause.
Yes, yes.
You are referring, this is between you and the ICAR. ICAR may at times find that if you contravenes any of the clauses or the terms of the contract, it reserves its right to terminate.
Yes. And my lord, PF was on this basis.
Affidavits, and then come to page 233, 233.
233, my lord. Yes.
Roman 15. The council will not be liable to bear any expenditure on pension contribution and or on leave contribution or any other retirement benefits incurred or committed by the grantee in lieu of CPAF or GPF.
Yes.
So this is what they say, the council will not be responsible. That means impliedly the responsibility foisted upon you.
Yes. Then my lord will kindly read how the appointments took place.
Here.
We had been taking on the CPF contributory provident fund.
What you are trying to do is you are varying the service conditions. Because the KVK staffs, they were getting the facilities of GPF. I believe so. They were getting the facilities of GPF.
CPF. We were getting CPF. They were getting CPF. GPF is for the staff of the state.
So this is what they say, that you can't alter the service conditions because you will have to take it as your staff.
And my lord, I had actually also relied on one of the appointment letters.
You're not appointing them, sir. Kindly visualize, if you appoint an employee independently into your establishment, you can put certain conditions. There is no difficulty.
We had not.
But what has been done is that these staffs are taken into your establishment, lock, stock and barrel. That's all. You are never, by virtue of this, you becomes an appointee or appointing authority, but in reality, you are not. You need never appointed. But now disciplinary proceeding, everything can be done by them. So they are the appointing authority in that sense.
But I'll still rely on that one document of appointment and how these appointments had been brought in.
When you appoint an officer or a staff, you can definitely it is within your rights to impose any conditions. But because you are borrowed.
Yes, 100%. Therefore, the relationship of the principal, the agent, and the employee will come in.
For example, I'm giving
and has to be read together.
We are now facing in a recent times. There are many incidences of a merger.
Yes.
Of one bank into another. We have seen that this bank is now being taken over or merged with the another bank. those employees, their protections are always there because those employees of the bank which got merged, those employees will be regarded as an employee of the transferee.
Yes. The same happens when the companies get merged and amalgamated. And my lord, even in contract,
That's why I gave you an example.
and even in contract, there are merger of contracts. So I'm not.
Don't matter.
You know,
I gave an example for that. So what is the effect of this? Means those employees are now taken into your establishment. And if I am not wrong, this using the word, they are charged on your establishment. Is it a correct, appropriate word?
They are charged. I'll say they are grafted in it.
I am not very sure about that. But again, I'll rely on one clause of my appointment letter. If I will.
Doesn't have any relevance. I'm giving you some simple.
And I completely understand.
You never appointed them. So
Yes, my lord.
Visualize. I'm telling you very frankly. Suppose we have a employee of a Punjab National Bank. He, not Punjab. Now I can give you an apt example of Allahabad. He was appointed.
Yes.
By Allahabad Bank at one point of time. And it says that you will be provided with they say, this much of allowances for your residential quarter. Very simple. Agreement says. Now, Allahabad Bank merged with the Punjab National Bank and the Indian Bank. These are, suppose the Punjab National Bank. Punjab National Bank, when he appoints his staff directly,
my lord,
says that no, up to this, I will grant you a house rent allowance or not beyond. Can you now say that this appointment, these conditions is meaningless? Now it has come to me, my conditions are this. If the agreement does not permit alteration.
No, that's what I'm saying. There is a merger of contract. There is absolutely no the merger of relationship.
Whatever transpires from the contract is binding on you.
The contract, the MOU, is the principal document, and I'm admitting to that. I'm not saying that it is not. The statute.
In your affidavit, you say that actually they were under the CPF or a GPF. Under the GPF.
No. The state.
One GPF. University staff are already in GPF. We are also.
So you also want a GPF?
Yes, because they have been getting CPF, and the state, the university employees, in terms of the
CPF.
So the CPF
will be more beneficial.
The CPF gives one-time benefit. There is no recurring receipt of pension.
No.
But GPF.
Pension.
Yes, pension. Under CPF, there is no pension. But
pension or a provident fund? I'm still confused.
Under GPF,
contributory provident fund and the general provident fund.
The difference is this: in the contributory provident fund system,
where they have to make a certain contribution every month, matching contribution will be given by an employer.
And interest on that.
GPF is only the employee who makes a contribution. Yes. There is no corresponding obligation of the employer.
Exactly. Now, employer.
This is what I understand.
Yes.
That's absolutely right. But the employer does not make contribution under GPF.
Correct.
But the employer has the liability to pay pension, subsidy, and gratuity upon retirement.
Okay.
That pension is receivable month-wise, every month.
Yes, in contributory.
Somebody prefer to have the lump sum money at the time of retirement.
The clause is that the ICAR says I will not be responsible for any pension and the gratuity.
Well,
that means the responsibility is yours.
Well, then the whole question will come whether that liable entitled to pension or not. That's a different aspect.
The additional
and
the DCRB rules, which says that
which is extended.
Which is extended to this university.
Now, well, the contributory provident fund, they have it's an equal contribution. We have been contributing. I mean, the KVKs have been contributing. The ICAR, in effect, had been contributing, and the employees were also contributing in equal measures. Now, the employees, my lord, as I was saying, my lord, I will come back on that briefly. They were employed referring to the ICAR contract. They were put in. I'll just read one clause, if your lordship may allow me. this is page 83, clause 3. She will be on temporary service which may be terminated in event of discontinuation of the KVK by the ICAR. Under any circumstances, the continuation of service will not be claimed. Now, that is the nature of
That was the
appointments.
nature of the appointment. That was the
So,
nature of the appointment.
so we have to read two documents together. One, the MOU and the appointment document.
Now-
So the service relationship.
I'm again asking you that I think this appointment that was done after this KVK has been entrusted upon you.
The MOU, yes,
After the entire KVK is entrusted upon you.
right, my lord.
You have started the appointments.
In
the
in terms of the directions of the ICA, in terms of the directions of the MOU, I am not going anywhere outside of the contract. In my submissions, my lord, the MOU and the appointment have to be read together. The IC,
Next line
my
on
lord,
I have seen.
and the ICAR and ICAR is the grantor. They are the principal. I am a grantee. I am the agent and the
Okay.
of ICAR in terms of the contract.
Anyhow,
And that is how the relationship is. So that is my humble submission. That is what I was also working on, my lord. Other than that, really, my lord, there was this question of CPF and GPF. The GPF,
that your affidavit
yes,
is
I have,
clear.
yeah, very clear, my lord. The pay scales, the state's pay scale is the 6th pay commission. Here is the 7th pay commission that was implemented, which is a central pay commission. That is, well, those are the three things really. And of course, the impugned order has already been shown. The 4 other documents that were relied in the application when the appeal was filed, the 3 of which have been relied in this order 41.
No documents.
Yes, but these are documents that whether they can be brought in, whether they need to be brought in something.
That can be. If it is for pronouncing.
No, my lord, if it is required for your lordship's aid, your lordship can. The judgments are there. I'll not cite that. There is 2022.
Court onwards.
No, this is 2022
I can multiply many judges.
is the latest.
Satisfaction of the court. whether it
Yes.
requires a
So I will not.
for pronouncing an effective and complete judgment.
Yes, if your lordship really thinks these are required, in my humble submission, these are not required. The MOU is sufficient. And my lord, of these 4 documents, he has actually relied on 3 documents in his order 41 application. That I must point out to your lordship. Other than that, just lordship, can you please go ahead? I think that is where I will stand. My entire stand is on the MOU,
Yes. We'll interpret. No,
the
no
appointment.
difficult.
The 2.
Who are you?
I am ICAR, my lord.
Nothing to say.
Yes, my lord. My lord. MOU is sufficient, my lord.
Except for very meaningful appearance. You have entered into a contract. You have given a responsibility to the university.
Exactly.
Now it is the university who has to take care of them. You have washed your hand.
But-
Except one thing, that if they contravene, you can terminate the MOU, you can terminate the project, everything you can do.
My lord.
Till date, you have not done. Complete?
My lord.
Yes, thank you. Calculate dictation in the open court, I will do.
Lordship.
Tomorrow. और एक बार फाइल का पढ़ लो। You're not understanding only that concept. Law to good efficient. The application to dispose of wetland, so you can treat a documents. Yes, tomorrow will dictate it.
Will my presence be necessary for this? No.
If otherwise,
My learned junior.
otherwise beneficial, then you
No.
can.
But that never. I never done.
My lord, everything is
I know it. I know
pretty
it. That's
clear
why
on records.
Just hinted, if it is otherwise beneficial, no difficulty.
But my lord, in the event your lordship needs any factual
I'll
update, my lord junior will be.
I will request you to call.
No, my lord junior will be. He is posted with us. He is very sincere.
Who who dispute?
He appears with me, in many matters.
Now it is,
I have always
it
found.
is a duty of you seniors to groom these good
He was
juniors.
originally not my
They-
junior.
At one day, at one point of time, they will be the leading the
Yes.
bar.
My lord, initially he was not my junior. He was junior in the chamber of Justice Dipankar Dutt.
Okay,
After his lordship,
that's true.
after his elevation, then.
Very nice.
Yes.
He had a too good, wisest of brain. That's advantage he had. Yes.
Much obliged, my lord.
এটা এসছে? This how much time? Can we come after 5 minutes? The list is coming, otherwise again another matter we will not be able to take because 12 noon you say is the deadline. what they have said. Presentation form you have said here, there. Just wait. This is the. At least file টা কোথায়? I am told that it is gone, the file has gone there.
কি রে? But I'm told it's written as court number 8.
Saying it has gone to courtroom number 1.
দৌড়ে লোক
পাঠিয়েছি
extra copy আছে?
হ্যাঁ স্যার মানে এই তো মেমো আসছে
সব কাগজই চলে গেছে ওখানে, সবই ওখানে চলে গেছে। But maybe start with a white copy if your lordship's permit.
Do you have the extra copy?
We have one extra copy. দুটো হবে? এই তোর কাছে নেই? দীপাঞ্জন?
না আমার কাছে তো সব
Have one my copy, I can hand it.
আমি
to the
সার্চ
lord.
করেছি একটা set
তোমাকে সব কপি দিয়ে দেবে
দিয়ে দাও আপাতত দেখুন।
এসে গেছে মনে হচ্ছে। এসে গেছে।
ইনএলিজিবল নয় তাই জন্য সব বের করবো ঠিক আছে তাহলে আমি তাহলে 5-এ যাচ্ছি
চল।
You have created a problem.
কেন?
In a presentation form, what you have written, the Honorable Chief Justice and the Honorable Justice Hinanma Bhatta. So definitely the filing section has sent there.
এটা কবে লিখেছিস?
Today, I grant you a leave.
No, this was written below yesterday
No, no,
night.
This presentation form is filled today when you filed it.
Well, I'm told, subject to correction, Miller.
No, you wrote an email, that is what
Yes.
we get it from this.
Right.
That I understand. But the Honorable Chief Justice has assigned, you came and sought leave from us.
From this court, right?
Then why you will write in the presentation form to be listed there? This is what you have written. So naturally they have sent it there.
I'm sorry, Miller.
Who is the advocate and record? Why you have done it? When you sought for a mention, they leave. You knew it that this matter is assigned to us.
Apologies, your lords.
But this is a very short matter.
Just
I'm sorry.
Yes.
Now, my lord, dear lordship, may kindly have a look to, my lord, the pleading. Kindly take me on page number 18. Or page number 17, the last paragraph. This is part of the writ petition.
Is number?
Page number 17, para
The stay, the stay.
of the stay application.
Yes.
That the petitioner states that the petitioner intends to organize a peaceful rally on 9/1/25 between 1 p.m. to 5 p.m. starting from Robindra Sadan metro station to National Library by following all procedures as mandated by law in force. The rally will be covering the route of Robindra Sadan metro station, PTS crossing, Alipur Zoo to National Library. The rally is intended, this is very important, to be conducted to raise voice against the illegal commercialization of Alipur Zoo. This is what they say. Nothing more, nothing less. Now kindly take note of the application which your lordships would find, my lord, at page 41. Here also, my lord, subject prayer for NOC for protest rally against illegal commercialization of Alipur Zoo. So and so, times such and such, etc.
Yes.
But my first submission is, my lord, what is the rally about is vague. What do they mean by commercialization of the zoo? Nobody knows. Number one. Number two, assuming for argument's sake that it confers some meaning. My lord, running of zoo is not the sovereign function of the state. Money is spent by the state, but it is not a sovereign function of the state. Number two. Number three, my lord, is that what is the urgency? I can understand that tomorrow something is going to happen. Today I need to protest. So any day, any time, at undesignated places. Now, the Supreme Court has said that you cannot say that anytime I will go at undesignated place. This has been said in several judgments. Look at in one of them, that Shine-Bagh judgments. If my lords had been, hey, copy the judgment. Please have a look to this judgment, 2020, volume 10, Supreme Court cases, 439. Have a look to only 2 paragraphs. But the Supreme Court makes a distinction between pre-independence protests and post-independent protests. Please, only 2 paragraphs. I'll not detain your lordships. Para 16 and 17. India, as we know it today, traces its foundation back to when seeds of protest during our freedom struggle were sown deep to eventually flower into a democracy. What must be kept in mind, however, is that the erstwhile mode and manner of dissent against colonial rule cannot be equated with dissent in a self-ruled democracy. Our constitutional scheme comes with the right to protest and express dissent, but with an obligation towards certain duties. Article 19, one of the cornerstones of the Constitution of India, confers upon its citizens 2 precious rights: the right to freedom of speech and expression under Article 19(1)(a), and the right to assemble peacefully without arms under Article 19(1)(b). These rights in cohesion enable every citizen to assemble peaceably and protest against the actions or inactions of the state. The same must be respected and encouraged by the state, for the strength of a democracy such as ours lies in the same. These rights are subject to reasonable restrictions which inter alia pertain to interest of sovereignty and integrity of India and public order, and to the regulation by the police authorities in this regard. Additionally, as was discussed in Mazdoor so and so, each fundamental right, be it of individual or of a class, does not exist in isolation and has to be balanced with every other contrasting right. It was in this respect and in this case an attempt was made by us to reach a solution where the rights of protesters were to be balanced with that of commuters. However, while appreciating the existence of the rights to peacefully protest against a legislation, keeping in mind the words of Pulitzer, etc., in a democracy, I skip over the italics, we have to make it unequivocally clear that public ways and public spaces cannot be occupied in such a manner, and that too indefinitely. Democracy and dissent go hand by hand, but then the demonstrations expressing dissent have to be in designated places alone. The present case was not even one of the protests taking place in an undesignated area, but was a blockade of a public way which caused grave inconvenience to commuters. We cannot accept the plea of the applicants that an indeterminable number of people can assemble whenever they choose to protest. Rest I don't trouble, Millard. Therefore, Millard,
Yes.
Millard, the right to protest, Millard, is qua some duties of the state. Why the High Court is painted red cannot be a ground of protest. Just giving a hypothetical example, that why the High Court is painted red outside cannot be a ground of protest. Now, commercialization of zoo is being said. What do they mean by it? Nobody knows. Possibly they also don't know. Now, what is the urgency? That it has to, now, as your lordships are reading every day in the newspapers, that end December and the entire January, the visitors in the Alipur Zoo is the maximum number. Therefore, first is the visitors problem. There are the SSKM hospital, let me describe the route. But they are supposed to assemble in front of this Robindra Sadon metro station. Then they'll take the AJC Bose Road from in front of Calcutta Club. They'll proceed forward. SSKM, they'll cross the Police Training Institute, and thereafter they are going to turn left towards Taj Bengal and then end at National Library. Now, this is the proposed route. Now, my first submission is, Millard, what is the need that it has to be done in that route? Because it's not a designated route. It's not that Calcutta does not have designated places to protest. Let them do it at designated places, if at all there is some cause. But the cause, whatever may be the cause, the state cannot guide the cause. But that state, Millard, at least can say, or Millard, the Supreme Court has said two things. Whenever you choose, you cannot say that, yes, I want it now, so you have to allow me now. And number two is Millard, the designated places. Go and do it in designated places. Nobody is stopping you. Unless the designated places are occupied by some other persons already.
Yes.
Therefore, Millard, I very respectfully submit, Millard, if my learned friend agrees, and Ganga Sagar, another thing that I forgot to say. No. The pilgrims are here, everybody is seeing.
Almost empty now. The Ganga Sagar side, if somebody goes there, near Gangas, it's not that crowded as of now.
No, we have to send our police consignments to Ganga Sagar.
Gathered. The scheduled timing is from 12 to 3, although we prayed from 11 to 5. But court has reduced from 12 to 3. That to our the total number of participants was 3,000. That has been cut down by the court, and it has been said only 1,000 people can gather.
But the court has not considered whether it is a designated place or a designated
I am
route.
asking myself whether Hazra crossing is a designated place. Every time the ruling party, when they are having a meeting and protest there, is it a designated place? How they are allowing it?
It is your party who does it.
Yes, no. Hazra, everybody knows. In Hazra crossing, is it a designated place? Shambazar Mode, is it a designated place? How many meetings every year? How many meetings takes place there, Millard? And Millard,
But in none of them, Millard, the police had granted permission. Millard, these permissions came because of a situational need. Arjikor, as your lordship.
Not only that, I'm not talking about.
Therefore, Millard, the Supreme Court, the judgments, Millard, cannot be bypassed by showing certain examples, if at all, my lord, these are valid examples.
My lord, 12 to
Who
3.
is stopping them from, my lord, in that case, my lord, the entire Calcutta, my lord, I stay in Dhakuria, I feel Dhakuria will be the best place, I organize a rally over here there. Somebody stays at Goriahat, he feels that is the best place.
Not be able to organize. From where you will get the number of people.
He can organize.
No, I can participate in Mr. Datta's rally always.
That's true. I am never a leader, I am always a follower.
Personal capacity.
That's personal capacity.
So let them hold them in designated places. And what is the need on 9th of January?
Every time, if it is a 10, then why 10? If
Yes,
it's
yes, definitely.
why 11?
It must have.
That's what is one. Only thing is what is there. Number of peoples have been reduced.
Yes.
To 1,000.
3,000 to 1,000.
No, 1,500 was the application.
No, we said that 1,000 from Lord the
Hey,
3,000.
to 5,000.
But see my pleading, that was reduced.
No, your application at page 41 says
And
1,500.
your lordship knows from 12 to 3, considerably, Lord, it's a low traffic time.
No, Milord,
Your
the
lordship knows
visitors
this is number one. That is the Lord, reason court kept in mind the timing session, said no, you cannot do it at 11 from to 5.
So there are another thing, Mr. Majumdar, if you cross across the hospital, at least the hospital is such a place where the emergency is always there because it treats with the life of the human being.
That is the reason.
There should be any interruption.
No, that should
So
not be
far
done.
as the emergency services are concerned, there
Yes.
should not be.
Yes.
So this is what we are more concerned with, that if the hospitals are really,
That
irony is something different, but
if your lordship see the order,
at all, then
your lordship is absolutely correct. And order itself, the order under challenge, it has taken care of that portion also. My lord, kindly see it once. Kindly see the organization, this last but 3 paragraphs. The organizers shall follow all applicable laws, including norms regarding sound pollution and the like. So it includes, if there is emergency unit, the crowd has to follow the reasonable restriction. That your lordship can clarify. If your lordships want, your lordship that can clarify that.
and what did you do it in a very small designated channel? In a particular channel, so that at least the commuters or the traffic is not disrupted.
One side of the road will do it. It will not road both of the sides. Only one side the rally will go. They will go from the Ravindra Sarovar metro station. It will cross Ravindra Sadan metro station. It will cross PTS, Police Training School. Then they will turn left. Your lordship knows there is no.
No, I know. I can.
Yes, yes, I know, Malad. Then they will cross Taj Bengal. They will cross Taj Bengal in front of National Library. The rally will stop. This is the route map. And your lordship knows 12 to 3 reasonably. This is a low traffic time. That is the reason the court has reduced from 11 to 5.
But the court, with respect, has not gone into these aspects. That whether this is at all a cause of protest. And today, the example which my learned friend has given just before, from tomorrow, this again becomes a designated place because the court has allowed.
It cannot be.
Place is to be designated by the state.
It cannot be.
This is what the example my learned friend gives, Shambhajar. But let them do it at a designated place. The state is not opposing to that. And some good reason as to why it has to take place on 9th.
We have given representation on 2nd, asking us to give them to give us permission on 9th. 7 days prior notice has been given to them. How can they say, my lord, immediately we are going to do it?
No, I'm not saying immediately.
Notice. Your lordship knows it's sufficient to give.
But kindly see the footfall in the zoo now. Yes, newspapers every day. Yes.
And your lordship,
it's more. Yes, kindly see even on weekdays, But weekend, kindly see the last three. Weekend on 5th of January, it was 89,000. But on weekdays, like Monday and Tuesday, that is 26th and 7th, 27,000 and odd.
My lord, when the
Both
matter
days.
was moved before the single bench,
27,000 per day on weekdays also.
1,000 more will not make any difference, if
No.
at all.
But a visitor and protester,
It's a peaceful
different.
procession. My lord, kindly see the. my lord,
Who takes care of this
Right,
peace?
No, nothing like that. My lord, that already been taken care of by the order passed by the learned single judge. My lord, kindly see it once, my lord. Kindly see it once again, my lord. Yes. The organizers shall ensure no incitement to violence takes place.
Who is the
from rally.
organizer? Who is the organizer? There has to be some
That-
responsible person.
Yes, the petitioner himself. is
They
the
have not
responsible
given the names of responsible.
Yes, we have given.
Only one person.
Yes, kindly see the application.
Yes.
Yes.
Jabir Singh.
Para 1.
Organization will not take responsibility. He has not said that the organization has authorized him to apply. He is only using the letterhead pad. Where has he said that the organization has allowed him? Yes, designation doesn't mean that he has been authorized. But that is beside the point. That is beside the point. But right. Absolutely. Absolutely. Yes. But as of now, my lord,
Please reduce. Please reduce the number.
well, my very respectful submission is let them do it at designated places. Otherwise, my lord, please consider another one more thing.
86 days or 886 days. Do you have anything to say on this delay? You have not filed your opposition, sir. So that means the delay which they wanted a condonation has to be accepted.
Yes.
Despite the direction passed This order dated 16th October 2023 or 31st March 2022. What is this? Where is the order dated 31st March 2023? And, and 16th October 2023. You are taken around. এটা কলকাতা স্টেটাতে স্টেট অ্যাওয়ার্ড মানে there if your lordship kindly takes up what they are practically what has been done my lord at page 82 if your lordship kindly takes up page 82 of the stay application my lord a very short point my lord. The difficulty is you did not challenge the order dated 10th June 2019. You did not challenge that order. But my lord, at page now this particular writ petition number 4367W of 2019 was disposed of finally with categorical observations. Now, if it says that immediately you have to do it, that's why I wanted the learned judges said that these two orders are the contrary. I just wanted to see these two orders of 31st March 2023 and 16th October 2023. Show me these two orders. What are those orders? Page number 101. 31st March 101. This was passed in this matter. Not in this matter, my lord. Yes, this is a 26486. The present is so this matter is pending. What has happened? Then this was the 31st March, and where is that order? Subsequent order. What is this? That order of no, the last final order to 16th October. Your lordship. 16th October is the order passed by the authority. No. So this writ petition is pending. But with respect 4661 of 2023 is pending.
And disposed.
When?
Disposed. Disposed on. You already disposed, and after disposing, actually, 16th October, GI primary.
No, that I have seen. If your lordship takes up, don't worry. I just wanted to know this fate of this WPA 4661. Page 99. If your lordship kindly takes up, 99.
Yes. Page number 99.
This was the order dated 23rd August of 2023. On that basis, that is 461. 4661. Oh, there nothing, but only to take a recent order. Well, that's why a recent order has been taken up in 102. 1610, the order is passed. Order is passed. Correct. And denying. What is the effect of this 10th this order? The ultimately was there anything to be decided by you? Tell me. After 10th June order. 8434. You did not challenge this order. That means this order becomes final, attained finality and binding on you. The only issue is, I understand. Issue is whether if a person has resigned from service, whether he is entitled to pension.
our order category.
But why you did not? Why you did not take into account this order? The order may be illegal, but it is staring at your face. What the court has said on 10th June 2019. I think he's not aware of the nuances of the law. That's why he has come for the writ petition. Otherwise, he would have come for a contempt against this order.
I already filed contempt petition, your lordship. I am very important document I am producing before your lordship. Very danger.
Danger.
Rashtrapati Bhavan directed me yesterday at evening for producing this document before your lordship.
No, this was in this matter, this was passed. Ultimately, this final order is passed. This is not required anyhow. The point is different. Anyway. That was an interim order passed in this writ petition, which merged with the final order. Don't worry.
May I?
Tell me, you have not challenged the 10th June order. Can you go above the order of the High Court?
Certainly not.
So,
that can't be.
if your authority has really exceeded its jurisdiction, then what can be done?
In the revision, may I come back?
And there was no occasion for reconsideration of the representation. This order was very clear and categorical.
It attains finality otherwise. If
That's all. And the learned single judge has correctly said that this order runs counter to this order. How can it be sustained?
let me come back on Monday, Malad, for finally, Malad.
Kindly, sir.
Malad, kindly.
No, that is why I have got a strongest reservations. A person is appearing in person, he is approaching the court, and if the member of the bar asks for an adjournment that I don't know, then what for you have been interested?
Only on for that.
I have not read the whole paper. I read only the impugned judgment and put a question to you. You have no answer. And this is a pure question of law I am putting it to you.
Yes.
And for that you want an adjournment.
For a day, I have to know whether that separate appeal has been filed or not.
Against you. This order is not challenged by you in the higher forum. What is the effect of this? That means the order attains finality. Can an authority take a decision contrary to that order of the High Court? Simple question. As a counsel, tell me.
Well, certainly not. That.
Rightly, wrongly, what has been decided by the High Court. Can he go above the High Court? Very simple question. Asking for time to get prepared.
The only issue that whether appeal has been preferred, but right now I don't have the instructions.
Sir, you have not disclosed any facts, sir. And this is an appeal. You cannot bring a new fact. And what you were doing for so long. You are aware that this order is quoted in the impugned order. And the learned judge has said that this order is very categorical and the order of the authority is contrary to this order. If you are a good, you should ask the authority whether you have challenged this order or not. You did not. This is not expected. No, sir. As a responsible, is a citizen of the country who is coming and appearing in person, he should not be harassed in this way every time to come in the court and then wait. No, this can't. The appeal is Have you gone through?
I beg your lordship's pardon?
Have you gone through?
Yes. I'm carrying copies also for your lordships.
Yes. Yes.
The paragraph 7 or 7.1 onwards is the discussion on the specific performance issue.
Have you seen that? What do you find from this judgment?
From this judgment, my lord, the court held, my lord, that decrees of specific performance can be passed by the consumer forums.
To tribunal. Why you did not?
I was hoping to rely on the statute itself and convince your lordships, but I'm grateful.
So you were so sacrosanct on that and confident.
I was confident, yes.
Not so easy.
I bow down. Because the basic case, my lord, specific performance sought by them.
Division bench judgment.
Yes.
Yes, what do you say on the interpretation of the provisions? Let us go.
Yes. Simple case, my lord, just to summarize my submissions, my lord. Their plaint is a plaint for specific performance. In the prayers, they also specify the two things which they want through specific performance. One is money.
Payment of the balance money and the
execution
of the conveyance.
That's right. This is the manner in which they seek specific performance. The statute, the RERA statute, specifies various obligations of the allottee, which includes payment of money, which is sought by them, which also includes execution and registration of the conveyance deed, which is also sought by them. Specific performance, my lord, it's a generic term, my lord. How the question which arises, it's just a nomenclature. How is it to be performed? These two things.
There is a special act for that. It's
Yes,
not a
yes,
generic term.
Yes, specific relief act is of course there.
There is a special act for that.
Yes.
So
in
no
this
longer a generic term.
No, in this particular case, they want it in two manners, and both those manners are specified as my obligations in terms of the statute. The statute also provides that in case a person is aggrieved,
appeal to appellate authority.
First approach the authority, the RERA authority, and thereafter to the appellate tribunal.
Correct.
There are other provisions also in the statute, which I did not show your lordship yesterday, but I can show them to your lordship today, which also talks about, my lord, various other obligations or functions of the authority, specifically with regard to duties and obligations of the allottee. There are provisions in the statute also which talk about, my lord, directions which can be passed by the authority, as also the appellate tribunal, and that is a wide connotation. It's a very wide sweeping power in terms of nature of orders that can be passed by the authority. There are sections which also talk about interim relief can also be provided by the authority. Interim orders can also be passed by the appellate tribunal.
What I say. Even in implementation can be done.
Implementation and enforcement also. The rules also talk about it. The rules specific to Bengal. So, in summary, my lord, the subject matter of their suit could very well be the subject matter before the RERA authority, and therefore, the bar under section 79 necessarily comes in. Civil court does not have jurisdiction, and no injunction can be passed. If lordship wants, my lord, I'll point out the relevant sections, including perhaps some of the sections which were not shown yesterday or earlier. May I do so? Statute authority. Correct. Section 19, subsection 6, 7, and 11.
Section
6, 7, and 11, my lord. The relevant obligation so far as this suit is concerned.
referred.
Yes.
Yesterday you
Yes,
referred.
these I referred. 31 also I've referred yesterday
Yes.
about a aggrieved person. May I just point out 34, which I had possibly not referred yesterday. 34 F and G, functions of authority. Talks about functions of authority shall include
Compliance of the obligations
yes, cast upon the promoters, the allottees.
or regulations or orders.
Yes. And G is to ensure compliance of its regulations or orders or directions. Yes. So that is 34. Kindly, my lord, also this has been pointed out yesterday. 35, 36, 37, 38, and in particular, my lord, 37 and 38, which are very wide in nature. This your lordship has seen yesterday. "37 talks about directions. 38 talks about powers of authority, power to impose penalty or interest in regard to any contravention of obligations cast upon promoters allottees under this act or rules and regulations made thereunder. "40, my lord, talks about enforcement.
But have you seen when it is specified for a particular thing, can it be deemed that the other things were necessarily included? Because it talks about only three situations, the interest, penalty, and compensation.
That is so far as 38 is concerned.
40 also, recovery. Because this is only an implementing provision. There is no other
Yes,
provision.
yes. Can you see subsection 2, my lord, of 40? That perhaps takes care of what is troubling your lordship.
Oh, yes. 2.
Then, my lord, so far as the tribunal is also concerned, my lord, kindly take 53. This perhaps was not shown.
No, that is appellate tribunal.
Yes, yes, yes.
We
So
are
that,
not concerned
right,
with the appellate tribunal.
right. It has similar powers,
Whatever,
even for execution, which is 57.
whatever. We are not concerned
Very
with
well,
that. We
very
are
well.
concerned with the regulatory authority.
Yes, and so far as, my lord, the rules are concerned, my lord, this perhaps had shown your lordship yesterday, 26 and 36.
Yes. Order 21 is robbed in.
26 more than 36. 36, a small portion is relevant.
20?
26 of the rules. The rules. Rule 26.
The order 21 of
Yes,
the
yes.
code is clearly
Yes,
is
yes. And rule
followed by reference.
yes, and rule 36, my lord. 36G in particular, 2G.
That's fair. Yes. Number 2.
Lordship.
It a continuing matter.
As it appears, I'll be very candid. As it appears, from most of the judgments and the law, it seems it's against me. But for one small and a very, very tight window. Small and a very tight window. First, the only point that I want to make is, I'm not arguing whether they have the power, whether it's there or not there to enforce specific performance. I am not getting into that. I'll argue that presently. But Lordship, kindly take the 2005 judgment which fell from your Lordships yesterday, the Mandira Mukherjee matter. If you kindly take paragraph 7.1 just for a moment.
Spontaneously came in my mind.
But absolutely correct. No, but I found another one delivered by your Lordship of 2011 on the same issue. And also checked up the Francis Martins. That was actually the first case where it got decided. But kindly, very small, 1.5 pages.
That's why I'm saying.
I have got it, kindly just take 7.1. I just want to show your Lordship something. If I may place this, that apart, the Specific Relief Act is a law that recognizes the right of specific performance of a contract available to a party aggrieved, and such relief can be had before the civil court. Now, there is nothing in the Specific Relief Act which provides that the relief under the said act cannot be had anywhere else other than the civil court. Then, a contract can very well be enforced before an arbitrator if it contains an arbitration clause. Of course it can, because that's the contract. So, a arbitration tribunal, an arbitral tribunal, cannot be equated with a statutory tribunal. The arbitral tribunal's powers are restricted to what the parties agree. Unlike a statutory tribunal, which is under the statute.
Party-centric forum then.
Correct. Now, kindly also, I also want to show this. It's my duty, 7.3, I want to draw your Lordship's attention. Kindly see this, True that this decision was related to arbitration, but that would not preclude, I'm sorry, Lordships found that, preclude the consumer forum to be placed in the shoes of the arbitrator, principally on the ratio decided in those decisions. The question is whether any forum other than civil courts can exercise discretion with regard to specific performance of contract for sale of an immovable property in terms of Specific Relief Act, or whether the jurisdiction of the consumer forum is excluded by reason of any provisions of the Specific Relief Act. If it can be true in relation to arbitration, there cannot be any bar of it being equally true. This perhaps is a questionable part, because a statutory forum, a tribunal, can't be equated with a forum or tribunal which arises out of a contract. And the Specific Relief Act cannot and will not provide where it can be done. It's the act or the statute which creates that particular tribunal which will decide whether it has the jurisdiction or not. I'm still not on the issue. I'm not joining issues with your Lordship that the tribunal has a power to specifically enforce. I'm not on that. Yes, they do, but there's a rider. Now, kindly take one decision of the Supreme Court, copy down, 2021, volume 18, Supreme Court cases, page 1. Kindly just have a look at this, I don't want to trouble your Lordships with the entirety of the judgment. It's a longish decision, Kindly, come straight away, to page 34 at paragraph 80. 80, 34. SCC online ta diyeche to? SCC ta diyeche to?
Yes.
May I place this part, The opening words, this I'm sorry, is in respect of the RERA Act, The opening words of section 71(1) of the Act makes it clear that the scope and functions of the adjudicating officer are only for adjudging compensation. under sections 12, 14, 18, and 19 of the Act. If the legislative intent was to expand the scope of the powers of the adjudicating officer, then the wording of 71(1) ought to have been different. On the contrary, even the opening words of 71(2) of the Act make it clear that an application before the adjudicating officer is only for adjudging compensation. Even in section 71(3) of the Act, it is reiterated that the adjudicating officer may direct to pay such compensation or interest as the case may be, as he thinks fit, in accordance with the provisions of sections 12, 14, 18, and 19 of the Act. This has to be seen together with the opening words of section 72 of the Act, which reads, while adjudging quantum of compensation or interest as the case may be, under section 71, the adjudicating officer shall have due regard to the broad parameters to be kept in mind while adjudging compensation to be determined under section 71 of the Act. Then, Millard, kindly take paragraph 85. Millard, 82 to 84, Millard, are Millard, the Act again on 12-14. Kindly take 85, Millard. Now it deals with the whole Act. From the scheme of the Act, of which a detailed reference has been made, and taking note of power of adjudication delineated with the regulatory authority and adjudicating officer, what finally culls out is, I'm sorry, Millard, although the Act indicates the distinct expressions like refund, interest, penalty, and compensation, a conjoint reading of sections 18 and 19 clearly manifests that when it comes to refund of the amount, interest of the refund amount, or directing payment of interest for delayed delivery of possession, or penalty and interest thereon, it is the regulatory authority which has the power to examine and determine the outcome of a complaint. At the same time, when it comes to a question seeking the relief of adjudging compensation and interest thereon under 12, 14, 18, and 19, the adjudicating officer exclusively has the power to determine, keeping in view the collective reading of 71 read with 72 of the Act. Now, if the adjudication under 12, 14, 18, and 19, other than compensation as envisaged, is extended to the adjudicating officer as prayed, then in our view is extended to the adjudicator, in our view, may intend to expand the ambit and scope of the powers and functions of the adjudicating officer under 71, would be against the mandate of the Act. He has limited powers, Millard. He cannot, Millard, this is a contract. If the contract fails, and a tribunal which has, Millard, been constituted only for a very specific and limited purpose, Millard, I put this question to myself, can that tribunal, Millard, seek an enforcement of that contract? That's the domain of the civil court. Unless lordships are more aware than I am, section 9 of the CPC, Millard, is a complete, Millard, it's a plenary jurisdiction of the civil court, unless it's specifically taken away. Millard, here, Millard, it's not been specifically taken away.
By
Express,
implication.
Millard, such, Millard,
Section 9, read it.
no, I know, Millard, that necessary implication, Millard, that necessary
implication.
Millard, so that implication has to be necessary, Millard. Lordship is correct, Millard, but it has to be necessary, Millard, in the Act, in the Red Act. Lordship will not find that. Millard, the execution referred to is of an order which they can pass. Yes, Millard, of course. If there's an order, let's say, for refund or compensation or payment of penal interest, well, of course, if I don't pay, Millard, they can enforce, they can execute. I am not, Millard, joining issues there. But, Millard, my point is, if it's not clothed with a particular power to deal with a particular dispute, then, Millard, the question of, Millard, enforcement of that or any order seeking, Millard, enforcement of that may not, perhaps, Millard, be within its jurisdiction. This, Millard, only is the limited argument, Millard, which I had to make. Powers of enforcement, execution, Millard, I am not, Millard, challenging any of that. But this issue, Millard, that it does not have the power to, Millard, order a specific performance of a contract That, my lord, and my lord, the Supreme Court, I thought, my lord, was in fact, my lord, may I again take 1 minute of your lordship's time? If your lordship was, my lord, making a query while my learned friend was placing section 40, my lord, kindly see 40 subsection 2. May I place this, my lord? If any adjudicating officer or the regulatory authority or the appellate tribunal, as the case may be, issues any order or directs any person to do any act or refrain from doing any act, then which it is empowered to do under this act. Only then. Correct. In fact, my lord, if your lordship see the jurisdictional bar section, which is section 79, my lord, it also uses, my lord, the same terms. No civil court shall have jurisdiction to entertain any suit or proceeding in respect of any matter which the authority or the adjudicating authority officer or the appellate tribunal is empowered by or under this act to determine.
Yes.
Lord, those are my respectful submissions.
That's section 71, which has been.
Only on this judgment.
Yes, yes. So far as the judgment talks about section 71, I've only heard Mr. Mitro's submissions. I haven't seen the judgment.
Sorry, sir. I'm so
No
sorry.
difficulty. But from what I've understood, my lord, Mr. Mitro says, my lord, that section 71 and this judgment deals with the aspect of compensation. How the authority has the power to adjudicate with regard to matters of compensation. Section 71 is limited only to the aspect of compensation. It does not deal with the other powers of the authority. So this judgment perhaps is limited only to the aspect of compensation, but that does not denude, or the Supreme Court is not saying
I'm appearing on behalf of the appellant, my lord. This is the affidavit of undertaking, my lord.
Have you got that
Yes, my lord.
now?
My lord. Paragraph 9, 10, 11, 12.
Yes. You are accepting it?
9, 10, 11. Lordship. Chief, তোমার client.
দেখো।
For there. I am for there.
This is FMAT. What is this FMAT?
Yes. Well, it's suit for recovery of possession
Against you.
filed by my client, my lord, on the ground that the defendant on the allegation that the defendant is a trespasser. And my lord,
To give up the position immediately.
yes,
Temporary mandatory injunction against the defendant to throw him out of the position.
the defendant took the defense in the written statement that, my lord, they are in adverse possession.
Correct.
The suit was tried and, my lord, a decree was passed in my favor.
Correct. FMAT, why?
Yes.
Remand?
Remand. Yes.
Oh. Okay. Yes.
Yes. Now, my lord, an appeal was.
Not injunction, that's why
Oh,
I asked.
oh, oh.
FMAT normally from
That's
interest of a
true.
few
That's
others,
true.
that's why I asked.
That is true. Now, the appeal was preferred. After the appeal was preferred, quite sometimes thereafter, the appellant, the defendant appellant had made an application under, my lord, Order 41, Rule 27, saying that it wants to disclose further documents without, my lord, any document.
Without specifying what those documents are.
And without, my lord, annexing or, my lord, filing a copy of any such document. Without annexing any copy of such.
Correct.
During the pendency of the appeal and that application, a second application was made. Again under Order 41, Rule 27, on different ground. And, my lord, again, not annexing any copy of the.
Nor the disclosure of the nature of the document.
Nature of document, yes, electricity bill.
Okay.
I will show you, your lordships. Now, the first appellate court, my lord, was pleased to, my lord, pass the impugned order of remand, my lord, an open remand that everything is to be decided. The trial court did not decide, or the trial court did not decide, or the first appellate court did not the trial court did not decide the question of the adverse possession.
Was there any issue framed?
Yes. No. No issue specifically. That is the point, my lord, of the first appellate court. Now the parties went to, my lord, trial on the basis of the written statement, knowing, my lord, the case of the, my lord, parties.
Adverse position. Did they ever anything in the evidence regarding adverse?
No evidence laid. No evidence laid.
No evidence, not a whisper of adverse position.
No evidence laid, my lord, to
Whisper of adverse position was there.
in the evidence, yes.
Show me that when they claim this position to be hostile.
Page 22.
Kindly come to the written statement, my lord, page 24. May I read out? Paragraph 5 of the written statement. The suit is barred by the whatever it is effect of the law of malignant effect of the law of limitation. Yes.
Oh, very dangerous, very.
Yes. Malignant effect of the law of limitation as well as adverse possession. That the plaintiff as well as their so-called predecessors as named in the plaint have no possession in respect of the properties described in the schedules of the plaint for more than 50 years. And this defendant, including their father, have been possessing the schedule mentioned properties uninterruptedly, peaceably, continuously, openly, and adversely denying right title, continuously, openly, and adversely denying the right title interest of all others.
Hostility has not been given. Hostility is not given. That's the missing expressions. Otherwise, all the expressions of the adverse position is pleaded.
Yes.
Continuously, openly.
Hostile.
No, hostile word has not.
Now, if your lordships, my lord, this was the defense. Now, if your lordships are pleased to come.
Evidence.
The evidence is not here, my lord.
No, you must have a copy.
Yes, yes.
Give it to your senior. You have not given it to your senior.
I said, my lord, it's not there, my lord. On record.
They must have reproduced this paragraph in the affidavit as to examination in chief. What is the cross examination?
Kindly give me a minute's time, my lord. May I read out, my lord? The cross-examination. I have no document at present to show that I run a business of straw cutting machine. Well, that is the allegation in the written statement. I have filed document to show my possession. I have paid tax in respect of the suit property. I have forgotten to file it. I do not remember the exact date of my possession. Ramlakhan Jadhav died 25 years ago. I cannot file the death certificate of Ramlakhan Jadhav. He claims to be the son of Ram.
Entry has he said about it? The entry was illegal or something forcibly or something?
No.
How he entered into the position?
The entry, my lord, they say that, my lord, it was from through his father.
But father, how father entered? Which is one of the very important ingredients of
the entry. It has to be unlawful from the very beginning.
Correct.
No. I'll show you, lordship. I will try to show you, lordships. No. In chief, my lord, this is what he says. Myself and my father and my sisters and brothers have been possessing the suit properties uninterruptedly, peaceably, continuously, openly, and adversely, denying right title interest possession of the plaintiff and their predecessor.
That is in cross-examination I just wanted. Anything you have suggested that you have come in the position, anything on the basis of a grant or a authority or something?
No. The case of the plaintiff is, my lord, this Ramlakhan Jadhav used to carry on business there. Thereafter, my lord, he had handed over the business to the plaintiff number 4, and thereafter the property was in possession of the plaintiffs who purchased the property from the erstwhile owner. Thereafter, my lord, the plaintiffs were not in Calcutta, and in that point of time, the defendant had forcibly entered into the property. That is the plaint case.
I'm just reminding you of AEJ Carapier's case.
Yes.
That is what I'm reminding.
Yes.
That whether you have put your case, whether you have put any suggestions in the cross-examination. It is only on that basis I'm asking you this question.
My lord,
61 Calcutta,
61.
AIR 1961 Calcutta.
Subject to correction, my lord, subject to correction.
No, 61 or 51?
61,
61. 61 is a gut feeling.
Yes, 61.
AIR 1961 Calcutta. And anybody in the library?
আমার কাছে পুনরায় আছে AEG therapy.
AEG therapy. I correctly remember.
359 or something like that.
Judgment, if I
Yes.
of Justice P.B. Mukherjee. P. Mukherjee is confirmed on the P or N.
61 Calcutta 359.
By P.N. Mukherjee?
No,
PB Mukherjee.
That's why I say P. Mukherjee is confirmed on the P and N.
Yes.
Give me, do you have the full text?
Yes.
Hey, ছেড়ে দাও। পেয়েছি। Paragraph 10.
Gotcha. The law is clear on this subject. Sorry, Mal.
Yes. No, you read from the.
I'll do that from the book, my lord. It becomes
Better.
easier for me.
350.
359.
359.
The law is clear on the subject. Wherever the opponent has declined to avail himself of the opportunity to put his essential and material case in cross-examination, it must follow that he believed that the testimony given could not be disputed at all. It is wrong to think that this is merely a technical rule of evidence. It is a rule of essential justice. It serves to prevent surprise at trial and miscarriage of justice, because it gives notice to the other side of the actual case that is going to be made when the turn of the party on whose behalf the cross-examination is being made comes to give and lead evidence by producing witnesses. So, my lord, the defendant.
This is what I wanted. He says that openly, continuously, uninterruptedly.
That suggestion, my lord, was to be given to my witness.
To their witness, to your witness as well, and to you also on cross-examination.
To me on cross-examination.
On your behalf, the cross-examination. That suggestion, that should also come from your end as well. Because you wanted to seek put your case there and wanted to seek a denial. You could have placed a question when your entry was there. What was the date? Can you specify when you entered? When you claim a adverse position, I tell you why I say you, because you are supposed to put the plaintiff case in the cross-examination.
Yes.
It is a defendant who has to put the defense case in your cross-examination.
That's
this
true.
is what the rule of evidence says.
That's true.
Now the question is, when you want to prove your case, then in that event, if any initial onus lies on him to prove it.
Yes,
adverse position.
absolutely.
But the moment they utter a single word, they have said, maybe without anything, that there should be some suggestion in the cross-examination on the point. If you do not put those suggestions, then the second one is that it will be deemed that you have accepted the statement, paragraph 10, last sentence.
May I continue? It has been stated on high authority of the House of Lords that this much a counsel is bound to do when cross-examining, that he must put to each of his opponent's witness in turn, so much of his own case as concerns that particular witness or in which the witness had any share. If he asks no question with regard to this, then he must be taken to accept the plaintiff's account in its entirety. Plaintiff's account.
Sir, then I give you an example of another judgment of the Supreme Court. That the using of the word plaintiff and the defendant, these are interchangeable. And don't interpret the judgment of the court as a statute.
No, I'm not, my lord. The only difficulty.
I'm giving you Meenakshi Sadhu, judgment of the Supreme Court, where section 14(3)(c) was taken into consideration of the specific relief. The word defendant was used. Then it fell before the Supreme Court that this defendant must be deemed to be a defendant in that sense. Supreme Court says no, nothing. Defendants and plaintiffs are interchangeable, so it will be deemed that the plaintiff is also included there. Meenakshi Sadhu versus Sushil Kumar, Agarwal or Sarma, I do not know, these two. Meenakshi Sadhu will be the second respondent. I think Sushil Kumar Sarma or
Sushil Kumar Agarwal.
I do not know. Agarwal or Sharma. Both are not same. Have you got that? Sushil Kumar Sarma or Meenakshi versus Meenakshi Sadhu? So don't go by the magical word of the defendant.
No, for this simple reason, my lord, I'll tell you, lordship, the logic which I understand to be there is,
I think 2015 judgment, probably.
That, my lord, the plaintiff, the witness of the plaintiff has to be suggested with a case which the defendant is, my lord, trying to make out.
Has he put any question to you? You're in the cross-examination.
I'll read out the, my lord. I will read out. In chief, I say, may I
You have
read out?
denied.
In chief, I make out a case.
No, you have denied in the chief about
Yes, but my case,
adverse position.
my positive case, we have our residential building just adjacent to the A schedule property. And since November 2009, and I and my wife had been in Mumbai, where my sons are living for their respective job
What
of
is your case that he forcibly entered?
That's true. That's true.
No, I'm talking about adverse
Yes.
position. Have you denied in the chief?
Yes, that case. Yes.
That I deny and dispute that he has acquired the right by way of adverse position.
Yes.
Have you got that judgment?
I have 2018 October, my lord. I have found out one 2018 October Supreme Court. Sushil Kumar Agarwal versus Meenakshi Sadhu.
Yes, that is the judgment.
Justice Chandrachud's judgment.
Yes, that is what I'm saying. Section 14(3)(c).
2019 2 SCC.
19-2.
Yes. Have you
Yes,
had that
yes.
in your chief?
It is not a fact that the entire A schedule property are in alleged possession of the defendant, or that he allegedly runs this straw cutting machine, or that electricity connection stands in the name of the alleged grandfather of the defendant. It is not a fact that the defendant did not trespass into the suit property. It is not a fact that the plaintiff are not entitled to get any relief as prayed for. I have filed the certified copy of the registered indenture being number such and such. Now, cross-examination. Chief, page 3. Yes. One more, my lord. It is not a fact that the defendant number 2, including their father, have been in alleged possession of this said property uninterruptedly or peaceably or continuously.
And in the cross-examination?
Yes. In cross-examination, I shall read out. It is a fact that the defendants have taken possession of the suit property entirely. The defendant took possession of the suit property between November 2009 to February 2010. When they took possession, I was not at Asansol, I was at Bombay at that time. When I came to Asansol after February 2010, I came to know about my out of possession over the suit property. I came along in February 2010. I approached the local police station, but they did not help me as there was intervention in the matter. I served notice through my learned advocate. I have already filed the copy of the notice before this court. Then question number 27, my lord, I should point out, not a fact that the defendant number 2 is possessing the suit property since last 50 years.
This is what that means. Suggestion was given.
Yes. Not a fact that Horikishan Shaw and Kedarnath Darukar.
That is what they have to put that question that he is there, then you are denying.
Yes. Now, my lord, kindly, may I show the chief?
May I have that judgment?
Yes. Page pe koto bolle?
Sir,
241 or something.
41, yes.
Is number 2018 241.
241. 2019.
2019.
19 to 19 to is what?
এই অ্যাফিডেভিটটা কোথায় আছে? ও ওটাই সরি। কোন পেজ? যে does not know the units of which page?
Next page. These questions. So that he said obstacle groups. Not affected and not affected.
Where to see?
Yes. Interesting. Anyhow, 25 and 27 is the answer. So anyhow, it is out of way.
The sessions are there. I'll show you, Your Lordship.
No, the word defendant and plaintiff, don't be so rigid on.
Very well, very well. The suggestions are also there. I can show you, Your Lordship. Now, my lord, in this background, if Lordship, my lord, I can place the evidence. Now, in this background, my lord,
So there are two aspects.
Yes.
Suppose if they want to rely upon certain documents, the documents is concerning the electricity bill, concerning any, what other documents? Electricity bills and?
I'll tell you. Kindly give me a minute's time, I'll tell you. Kindly come to my lord, page 58. May I read out? Page 58 is the first application.
It's a vague application according to you. They do not specify what documents, simply say they wanted to rely upon certain documents.
Yes.
Did they specify the document?
No.
Page 65.
And that's the second application. Well, I shall come to that.
That is the first application. You
Page
say the way-
58. Page 58 is the first application, no particulars.
Correct.
I'll read out, my lord, so that, my lord, there is no confusion that the appellant defendant has adduced oral and documentary evidence before the learned court below at the time of trial of the suit, so as to prove his case before the learned court below. That the appellant defendant could not produce the electric bill, establishment certificate, and other cognate documents at the time of trial of the suit in spite of due diligence on the part of the appellant defendant. The appellant defendant did not know about the actual possessor or keeper of the electricity bill, establishment certificate, and other cognate documents at the time of adducing evidence before the learned court below. This is his case. That the appellant defendant came to know about the details about the above mentioned document after the dismissal of the title suit in the lower court below and during the pendency of the present appeal before the.
And first application vague.
This is the first application.
Okay. So
No schedule.
Electricity, certificate of establishment,
Yes.
etc. Other cognate documents. Not specifying what those are.
Not specifying, not annexing.
Whatever. Second.
The second application, my lord, starts at page 62. May I read out? The appellant defendant could not produce several important documents more fully stated and described in the schedule appended with the petition.
What are those?
I shall come to
Schedule. Straight away, come.
No, may I read this paragraph and then come on it?
Due diligence part.
In the schedule
important document
appended with this petition at the time of trial of this suit in spite of due diligence on the part of.
that has to be there.
One more line.
One more line.
And as the appellant defendant was not keeping well physically and actually owing to onset of cancer disease in the midst of the trial.
I was not thinking about the genuinity of the
Very
ground.
No.
I was thinking about
Schedule.
The value of those documents.
Schedule.
What are those documents?
Electricity bills for the year
That was also there then.
Electricity bill for the years 1982, 83, 84, 85.
Electricity bills, apart from that.
Trade license, municipal corporation tax receipt for the year such and such.
Standing Ulu's name, nothing.
No.
Okay, then any other?
Certified copy of case number MP case number 608 of 1980.
MP case number? Oh, there's 144.
140.
Of?
1983.
Okay.
That is it. Miscellaneous tax receipt. Sorry, I missed. Number 5 in the schedule is miscellaneous tax receipt.
Correct.
Now, my lord, I have twofold submissions before your lordships. First is that, my lord, on the basis of the evidence, my lord, the court could have disposed of the first appeal without, my lord, remanding it back on an open remand. Because, my lord, the law is well settled. Our High Court, Supreme Court.
The primary argument against a remand. Everybody does so.
I don't get much opportunity, my lord, to argue on this.
Everybody is the first point which is taken. The appellate court was competent enough under order 41, rule 25
and
25, that he can take an evidence and can decide. Then the counter argument comes that why a person must lose one forum.
Then comes, my lord, the question of order 41, rule 27. Whether, my lord, that application ought to, or those applications ought to have been allowed without even looking into the documents.
Without even looking into
the documents.
So,
I really do not know, my lord, when it is being sent back, that you take fresh evidence on the basis of these documents, my lord, the documents have to be looked into. The documents are not produced before the court.
yes.
The documents are required to be looked into, my lord. Lordships are aware of the, my lord, the cases on order 41, rule 27 also. For, my lord, sending back to take evidence on a particular document, my lord, in my respectful submission, the document has to be looked into. Without looking into on the basis of vague allegations that electricity bills for the year so and so, in whose name? Which property? Nothing given. On the last occasion, when it came up before your lordships were pleased to inquire as to whether, my lord, it was filed by way of fiduciary or not. My submission was, my lord, that not even, my lord, it was filed not even by fiduciary. Now, trade license, again. And, my lord, kindly look into the conduct, my lord. The first application is, my lord, blissfully vague as to why, my lord, the documents were not produced. It was some documents which were with somebody whom I do not know. The second application comes. The second application comes saying that he was suffering.
After so many, yeah, I mean the period.
My lord, possibly, my lord.
First application was taken out.
I'll
top of it, you will pay.
I will, my lord. 50 টা কবে বলো তো? 2019, the first application, and the second application is 2023.
Gap of 4
9th
years.
April 2023 and 12th December, 9th April, 9th April 2019.
Nearly 4 years.
5 years, whatever it is, yes. And December 2023.
That's the first point. What is the second point?
And, my lord, question of remand.
Question
The remand.
that you have already argued.
Yes. These are the
What
2
is the
points.
third point?
These are the 2 points.
Third?
I could not frame the third one. Oh, sorry. And, my lord, possibly the non-framing of issue. Yes. The court, the first appellate court was pleased to observe that, my lord, issues were not framed on.
Where are the judgment? Justice Anil Kumar Sen's judgment. Non-framing of the issue. Not fatal. If the party knew, if the parties knew what are the issues and let an evidence, then mere non-framing of the issue is not fatal. I think the parent judgment is of Justice Sonil Kumar Sen. Third important point you are not taking.
My lord, on question of framing of issues, my lord, I came, my lord, with a judgment of a division main judgment of our court, my lord, reported in AIN 1987, Calcutta, page 240.
Justice Sonil Kumar Sen.
No, Justice Roy, my lord. Justice Roy.
The core principle of those judgments are that if the parties knew that what are the issues and let an evidence, then non-framing of the issue cannot be a fatal one.
No, absolutely. That's the law. That's the law.
So I have learned from you.
No, no.
Yes, any other judgment?
My lord, kindly come to paragraph 30.
That's true. Then, yes, sorry. Yes, yes, tell.
Paragraph 32, my lord. It's a longish paragraph, my lord. I'm trying to find out the relevant portion.
Almost middle.
এগুলো থেকে বার
Mr.
করতে
Banerjee,
That's true.
when the parties to the proceeding went to.
Towards the middle of that paragraph, my lord, in SCC online print, Lordship should find, my lord, that similarly, on fact, we cannot also agree with the submission of Mr. Banerjee, and that too on. Lordship's got that, my lord.
Yes, yes.
Similarly, on facts, we cannot also agree with the submission of Mr. Banerjee, and that too on consideration of decisions as cited at the bar, that the learned court below did any wrong in not framing such additional issues as claimed and as indicated by Mr. Banerjee, and that too when parties to the proceedings went to the trial with full knowledge of each other's case, and that being the position, the non-framing of such additional issue as claimed, even if the same was necessary, has not caused any prejudice to any of the parties to the proceedings, and they had in fact received all and every opportunity to establish their respective cases. Such and above being the position, we do not also accede to the prayer of so-and-so that there should be an order for remand to the learned court below for having the list duly and effectively determined on framing an additional issue as indicated above. And my lord,
Well settled proposal.
and This has also been said by the Supreme Court, my lord, very recently, my lord, in a decision reported in.
Just to make me updated. Yes. There? Yes, which one? Where is the latest judgment?
It's there already on, my lord, your lordship's note, I am certain.
No.
It's 2022, volume 7, Supreme Court cases, page 644.
644?
4.
Yes. Paragraph
Kindly come to, my lord, the last page. Paragraph 34.
30?
34.
4.
Yes. The objective of the provisions of Order 41, Rule 24 and 25 is that if evidence.
This is on a different score, that the appellate court should have taken up the responsibility of doing it.
It is only when the first appellate court finds that there is no evidence led by the parties, the first
Correct.
appellate court can call upon the parties to lead evidence.
Correct. That's
If
what
there is no evidence, then the first appellate court would
I
call
was
up.
having that proposition.
Yes.
Non-framing of the issue.
No. It's on remand.
It is on a different score.
একবার ওই order এই 2012 8টা দাও। And
What is that judgment?
my lord, on my lord, Order 41, Rule 27, it's
Remand.
on additional evidence.
Additional evidence. Order 41, Rule 27.
Lordship. Well, this is reported in 2018, Volume 8, Supreme Court Cases, page 148. Sorry, 2012, I'm sorry. 2012, Volume 8, SCC, page 1, paragraph 36. মিলবে না? SCC online তো সবসময় মেলে। The general principle is that the appellate court should not travel outside the record of the lower court and cannot take any evidence in appeal. However, as an exception, Order 41, Rule 27 CPC enables the appellate court to take additional evidence in exceptional circumstances. The appellate court may permit additional evidence only and only if the condition laid down in this rule are found to exist. The parties are not entitled to, as of right, to the admission of such evidence. Thus, the provision does not apply when, on the basis of the evidence on record, the appellate court can pronounce a satisfactory judgment. The matter is entirely within the discretion of the court and it is to be used sparingly. Such a discretion is only a judicial discretion circumscribed by the limitations specified in the rule itself. The appellate court should not ordinarily allow new evidence to be adduced in order to enable a party to raise a new point in appeal. Similarly, where a party on whom the onus of proving a certain point lies fails to discharge the onus, he is not entitled to a fresh opportunity to produce evidence, as the court can in such a case pronounce judgment against him and does not require any additional evidence to enable it to pronounce judgment. Under Order 41, Rule 27 CPC, the appellate court has the power to allow a document to be produced and a witness to be examined. But the requirement of the said court must be limited to those cases where it found it necessary to obtain such evidence for enabling it to pronounce judgment. The provision does not entitle the appellate court to let in fresh evidence at the appellate stage where even without such evidence, it can pronounce judgment in a case. It does not entitle the appellate court to let in fresh evidence only for the purpose of pronouncing judgment in a particular way. In other words, it is only for removing a lacuna in the evidence that the appellate court is empowered to admit additional evidence. It is not the business of the appellate court to supplement the evidence adduced by one party or the other in the lower court. Hence, in the absence of satisfactory reasoning for the non-production of the evidence in the trial court, additional evidence should not be admitted in appeal, as a party guilty of reminiscence in the lower court is not entitled to the indulgence of being allowed to give further evidence under this rule. So a party who had ample opportunity to produce certain evidence in the lower court but failed to do so or elected not to do so cannot have it admitted in appeal. The inadvertence of the party or his inability to understand the legal issue involved, or the wrong advice of a pleader, or the negligence of a pleader, or that the party did not realize the importance of a document does not constitute a substantial cause within the meaning of the rule. The mere fact that certain evidence is important is not in itself a sufficient ground for admitting that evidence in appeal. And my lord, kindly look into, my lord, a person, my lord, who says that I could not, the first application, I could not produce these documents because I did not know with whom these documents were lying. So how he came to know about the existence of the alleged documents is not disclosed in the first application. That is the first application. The documents, so he was in possession of the documents are not there along with the application. Then, my lord, after 4 years, he files a second application, he withdraws thereafter, he withdraws the first application. Oh,
No, he did not withdraw.
sorry, he did not withdraw. I said that I shall, my lord,
That he was ill,
he was ill, he was suffering from, my lord, the disease from which he has now recovered. Not a single document. Complete go by to the first case.
yes,
He gives a schedule in the first application, he does not give any schedule. In the second application, he gives a schedule,
but no documents.
no document, no particulars of the document.
To file opposition to both.
No, I said I shall treat the first opposition to the first application as the opposition to the second application. But that in my submission, even if I had not filed any opposition, my lord, this
Does not dispense with the
No.
onerous duty of the
of,
court. to
of
see.
the, I'm obliged, my lord, of the applicant.
That is what I understand from you.
বন্ধ করছি, চলো বাড়ি যাই।
Page 4 is there.
And my lord, my junior my lord, yes, rightly says, my lord, in examination, the defendant says, I do not remember the exact date of my possession.
Encircled it.
Yes.
Encircled. Let's say who are the owners of the suit.
I shall come to that. ওইটাকে ফার্স্টটা করো। Next, my lord, he says, I cannot say who are the owners of the suit property. Then Upadhyay plaintiff states at Mumbai before.
So please consider why I invited you for a third point. Third point, the reason is this. That even if this case of adverse position is there, then what are the elements which are required to be proved in order to succeed.
Those, I'm
So
sorry,
those ingredients, even if those documents are taken into account on a face value, does it really throws any light on the adverse position? One has to think. Suppose those documents are there. There is an electricity bill. There is a certificate of investment.
the evidence.
There is the tax receipts. Maybe is there. Does it throw a light on the
Adverse position.
because it is decided on a legal maxim nec vi, nec clam, nec precario. One has to. I learned.
No, no, but that's like a definitely.
Lord, before my lords rises, Lord.
Oh,
I'm sorry. We have to be excused.
So
কালকে হবে না?
what? Can you finish it tomorrow?
I can, but tomorrow or Monday, whenever it is convenient.
Whatever is convenient to both of you.
As your lordship pleases,
My bitter experience is there. That's why I'm suggesting any date.
but let Mr. Mitra, my lord, because he is my lord for the appellant.
Yes, tell me the date.
Monday, my lord.
Monday. Let the matter is substantially heard. Let the matter be listed on Monday. I mean date दिए दो for further hearing.
Lord,
Look into that aspect and you have a hilarious task on the basis of the evidence.
But I'll try to satisfy your lordship that whether the ingredients have been, my lord, either proved or attempted to be proved.
Mere
But it
long
was-
possession.
No, it
Mere
includes-
long possession does not tantamount to an adverse possession. Those line of judgments of the Supreme Court are also very clear. Yes, what do you want to say?
in the last occasion, my lord, it has been mentioned that item number 90. But today it was supposed to be taken up, but it could not reach.
Because of my.
No, not for. But
other
the
matters.
difficulty is this for, I have told you on the other day also, but from 10 to 17th, I'll be out of station.
Mind it, it will not be called.
Yes,
It will not be called.
after 17th, date to them.
17 এর পরই ওটা ডেট দিয়ে দাও 18 তারিখ তলায় দিকে
তুমি কি বললে এটা গামছা?